Members, please take your seats. Madam Clerk, please call the roll.
Mr. President?
All right, Senators, we have a very, very special guest today, someone who, now I have a full bio, of course, who just so happens to represent the 26th Legislative District, but is also the pastor at the Ark of Safety Christian Church, the presiding bishop of community churches that have dioceses covering the U.S., Nigeria, Angola, Ghana, and parts of South Africa. Please rise for the invocation from our wonderful senator from the 26th District.
Good morning. What a great day, isn't it? It's a great day. It's raining, and I am happy. Every time I feel the rain, I'm like, thank God I got food. I have everything that I need, and for that I give God praise. Mr. President, thank you for this opportunity to come and to just talk and just pray this morning. Just two things I brought with me. One is a chart that I take home. I pray for everyone here. I have a chart, the seating chart. You all have that. And I call out a section every morning of your names. And I just pray and ask God to make everything go well for you. And there are 3 names on here that I call out every day. It's called the troubled names. I won't call names like Folden and Will Smith, and I just won't do that. And don't you do it. My prayer goes this way. It was David who had a big challenge in front of him. And on that challenge, there was so much stress on him all the time. And right before he went into a great big battle, King David in the Old Testament, he wrote Psalm 27. I want to quote that and then pray and I'm finished. And that psalm says, "The Lord is my light and my salvation. Whom shall I fear? The Lord is the strength of my life. Of whom shall I be afraid? When my enemies and my foes came upon me to eat at my flesh, they stumbled and fell. Though a host should encamp against me, my heart will not fear. Though war will rise against me, in this will I be confident. One thing have I desired of the Lord, and that will I seek after, that I will dwell in the house of the Lord all of the days of my life, to behold the beauty of the Lord and to inquire in his temple. In the time of trouble, he will hide you and hide me. In the secret places of his tabernacle, he shall hide us." Pray with me. Heavenly Father, thank you for this good day. What a great day. I thank you for all of my colleagues who are here, the hard work that they do. I thank you for their families back home and that all is well. I thank you for the myriad of issues that we deal with day in and day out. And sometimes we get a little huffy with each other, but always we know that we are family. Thank you for that. Thank you for my hardworking brothers and sisters. I thank you for them. Now give us a great day. Grant us wisdom. Grant us courage. Grant us knowledge. In the name of the Lord we pray. Here goes another day. Amen. Amen. Thank you, Larry. Thank you.
The chair recognizes the chair of the committee who after all those special prayers that were being given.
Thank you, Mr. President. I would ask that the senator's words be journalized as a fantastic prayer.
Absolutely.
Oh, I appreciate it. I would always just say, God is good, God is great, let's get ready to legislate. But hey, that's my prayer. But hey.
Excellent. All right, good start of the day. Good start of the day. All right, if there are no objections, let's go ahead and journalize the wonderful invocation this morning from our excellent colleague who brings us with that enlightened spirit to start the day off the right way. Thank you, sir. All right, has everyone recorded their presence in the chamber? It appears almost so. All right, the clerk will take the call. With 45 members in the chamber and a quorum being present, the Senate of Maryland is now in session. We have a lot of work to do today. I believe we have a resolution to start. If we could start from the senator from District 8. We have some guests that are joining us for a resolution.
Thank you, Mr. President and members of the Senate. The National Council on Problem Gambling and the Maryland Alliance for Responsible Gambling has designated March as a Problem Gambling Awareness Month. And as we all know, we have gambling all around us. Wherever you go, there's somewhere to gamble. And it has become a unique problem. But problem gambling is a public health issue that affects millions of Americans of all ages, races, and ethnic backgrounds, and has a significant societal and economic cost for individual families, businesses, and communities. Problem gambling is treatable, and treatment is effective in minimizing this harm to both individuals and society as a whole. Numerous individuals, professionals, and organizations have dedicated their efforts to the education of the public about problem gambling and the availability and effectiveness of treatment. The National Council on Problem Gambling and the Maryland Alliance for Responsible Gambling invite all Marylanders to participate in Problem Gambling Awareness Month. Can the clerk please read the resolution?
The clerk will read the resolution in full.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to the National Council on Problem Gambling and the Maryland Alliance for Responsible Gambling in recognition of Problem Gambling Awareness Month. Thank you for your dedicated effort to educate the public about problem gambling and the availability and effectiveness of treatment. The entire membership extends its best wishes on this memorable occasion and directs this resolution be presented on this 5th day of March, 2024.
Clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Yep. Send. Anyone wish to change their vote? Clerk will call the roll. Take the call. The clerk will take the call. Excuse me. Look at this. Starting off right. To the folks joining us today from the National Council on Problem Gambling and the Maryland Alliance for Responsible Gambling, the Senate of Maryland unanimously thanks you for your work and thanks you for bringing this important issue to our attention and making Marylanders aware of the challenge. Thanks so much. Excellent. Thank you all for being here today. All right, so we have the equivalent. We have one more resolution. Well, actually, we have several resolutions, but it will be like the Kansas City Chiefs of high school sports, apparently, today. We are going to recognize a senator from District 9 who has 4 resolutions, and we're going to do this. We're going to do this quickly, but we have some impressive results coming out of a high school here in Maryland. Senator?
Thank you, Mr. President. Colleagues, today I'm breaking my streak of never doing a resolution to do 4 for River Hill High School Hawks. Our first resolution recognizes River Hill's baseball team, which is represented by student athletes Henry Zetkowski and Jake Miller, here with their coach Craig Estrin. Shout out to Harry, who in addition to being a state champion, was also named the 2023 Howard County Times Baseball Player of the Year.
The clerk will read the resolution.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to River Hill High School baseball team in recognition of winning the 2023 Class 3A Baseball State Championship. We applaud your outstanding season and wish you many more. Congratulations. The entire membership extends its best wishes on this memorable occasion and directs this resolution be presented on the 5th day of March, 2024.
The clerk will call the roll.
Mr. President?
Has everyone recorded their vote? If so, the clerk will take the call. To the River Hill High School baseball team, congratulations on your state championship. Well done. Senator from District 9.
Thank you, Mr. President. Next up is the River Hill golf team that made program history this year, becoming the first team in the country to win both boys and girls championships in an exciting match down to the final hole. The golf team is represented by Principal Robert Motley and Athletic Director Jimmy Creighton. Then the team is led by Coach Matt Graves.
Clerk will call the roll. Excuse me, we'll read the resolution in full.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to the River Hill High School golf team in recognition of winning the 2023 Class 3A State Championship. We applaud your outstanding season and wish you many more. Congratulations. The entire membership extends its best wishes on this memorable occasion and directs this resolution be presented on this 5th day of March, 2024.
The clerk will call the roll.
Mr. President?
Has everyone recorded their vote? If so, the clerk will take the call. To the representatives of the River Hill High School golf team, men's and women's, congratulations on your state championship. We are going to stay with the senator from District 9.
Thank you, colleagues, for your welcoming of this next group. The River Hill tennis team run their second consecutive Class 3A state team title in 23, also crowned champions in boys singles and doubles, as well as mixed doubles, with a runner-up finish in girls doubles. This standout team is represented today by Adele Lair, Adelaide Houston, Connor Chun, Alex Artizov, and along with their coach, Kelly Pfefferkorn. Congrats to you all.
The clerk will read the resolution in full.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to the River Hill High School tennis team in recognition of winning the 2023 Class 3A Tennis State Championship. We applaud your outstanding season and wish you many more. Congratulations. The entire membership extends its best wishes on this memorable occasion and directs this resolution be presented on this 5th day of March, 2024.
The clerk will call the roll.
Mr. President?
Has everyone recorded their vote? If so, the clerk will take the call. To the champions at River Hill High School tennis team, congratulations on your excellent state victory. Well done. And last but certainly not least, we're going to go to the senator from District 9.
Thank you all. Finally, we have River Hill's girls track team, which is represented by twin sisters Marella and Lauren Vermani. Along with their coaches, Amara Schmidt, Marella and Lauren finished their first and third place in the 1,600-meter run as freshmen. Talk about the athletic duo. I can't wait to see what you guys do next.
The clerk will read the resolution in full.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to the River Hill High School girls track and field team in recognition of winning the 2023 Class 3A Girls Track and Field State Championship. We applaud your outstanding season and wish you many more. Congratulations. The entire membership extends its best wishes on this memorable occasion and directs this resolution be presented on this 5th day of March, 2024.
Clerk will call the roll.
Mr. President?
Has everyone recorded their vote? If so, the clerk will take the call. To the ladies of the River Hill High School track and field team, congratulations on your wonderful state championship. Well done. Howard County, where the streets are paved in gold and the high schools are state champion. River Hill Day today. Yes, Chair recognizes the senator from the 38th District.
Good morning, Mr. President, friends and colleagues. It is Red Scarf Day, and I would like you to join me in welcoming the women that have come from all over the state, from Maryland's coast to Maryland's mountains, from the Maryland Federation of Republican Women. They're here to watch us in action and to join us. Please welcome them.
Welcome, welcome, welcome. Thank you all for being with us today. Thank you for joining. All right. Other introductions, Senator from District 40? Oh, nope. Senator from District 23.
Thank you, Mr. President. Colleagues, we are joined today by the Student Government Association of St. Pius X Regional School from Bowie, Maryland. I'd like them, if they're in the gallery, to please stand and be recognized. We have Miss Olivia, the SGA president, as well as Miss Kathleen McGinnis, who is their instructor. I want to thank them for coming and hope they have a great day in Annapolis today.
Is this St. Pius over here? No, no St. Pius yet? Okay. Are they on this side? We'll go back to when they come. We'll come back and make sure that they're recognized. Thank you, Senator. All right. Yes, Senator from District 6.
I don't know if they're here or not, Mr. President, but we've had Kenwood High School here today, so I don't know if they're.
Kenwood is in the house at the moment.
Okay.
So we'll get a notice when they join us.
Thank you.
Wonderful. All right, Senator from District 9.
Thank you, Mr. President. Colleagues, I have a non-Howard County visitor today. Henry Miser is a graduate of St. Mary's High School in St. Mary's County, and he's currently a freshman in Massachusetts. But today he's here in his capacity in advocacy around suicide prevention in the state school safety subcabinet. And he's worked really hard with me over the summer on SB 756, which will make our schools even safer. So I'd like the body to give him a warm welcome.
Welcome, welcome. Thanks for joining us. Very good. All right. Any other introductions? Oh, yes. Chair recognizes the Majority Leader.
Thank you, Mr. President. You might notice this morning that some of the women senators are wearing green today. in honor of the Equal Rights Amendment. And after session, we will be donning our yellow sashes, and we'll join each other out on the steps for a picture right after session.
Excellent. Well, in this Women History Month, we celebrate our wonderful women senators who are doing amazing work, and we appreciate you every day. Thank you all very much. Thank you. All right. Any additional introductions before we jump in? If not, so be considered the reading of the journal from the prior legislative day. We are done with introductions. We are now just going right into reports. So let's start with the Committee on Finance with report number 10. Clerk will read the first bill.
Senate Bill 178, Senator Klossmeyer, Agricultural Pollinator Habitat Plan Requirements for State Highway Administration, favorable with 2 amendments.
Recognizing the sponsor of the bill.
Thank you, Mr. President. Senate Bill 178 requires the State Highway Administration's pollinator habitat plan to include certain policies and procedures related to pollinator habitat areas along the state highway. Specifically, there must be policies and procedures to encourage the use of pollinator-friendly native plants along the state highways, to develop and maintain pollinator habitat areas along the state highways to the extent feasible and in accordance with relevant specified safety standards, and for educating and communicating with the public about the pollinator habitat areas along state highways. And as many of you might know, that bees are having a tough time in this world, so the more we can do for them, the better that they will survive and will continue getting our honey. Amendment number 1 requires the inclusion of policies and procedures to develop and maintain pollinator habitat areas along state highways, and to the extent reasonable. Amendment number 2 specifies an intent that nothing in the bill shall be interpreted to modify, limit, or interfere with state or local laws relating to weed control. And there was no opposition at the committee hearing. And before I finish, I just want to give a little trivia question. I know of one beekeeper in the Senate, so somebody's going to have to figure that out and see if they can guess who it might be later on. But I move the amendments and the adoption of the favorable committee report.
All right, the floor leader moves to the adoption of the 2 committee amendments to the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 178 is hereby ordered printed for 3rd reading. We'll figure out who that pollinator habitat maintainer is. Oh, of course, I knew that. Oh, yes, I did know that. I should have, yeah. All right, clerk, read the next bill. Senator from the 28th District is the answer.
Senate Bill 534, Senator Jackson, Electronic Transactions Protection Act, repeal, favorable.
Chair recognizes the senator from the 22nd District as the floor leader.
Thank you, Mr. President. Senate Bill 534 repeals an obsolete law that is no longer necessary as it relates to electronic transactions. There are no amendments, no opposition. I move the adoption of the committee report. Thank you.
Floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 534 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 705, Senator Hayes, Health Insurance Qualified Resident Enrollment Program Access to Care Act, favorable with 1 amendment.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President. Senate Bill 705 requires that the Maryland Health Benefit Exchange, in consultation with the Insurance Commissioner and as appropriate by the Exchange Board, to submit federal state innovation waiver to establish a qualified resident enrollment program and seek federal pass-through funding resulting from the implementation of the program. If the waiver is approved, the exchange, in consultation with the Insurance Commissioner and as approved by the Exchange Board, must establish and implement the program. The amendment includes clarification to the bill. The exchange must seek federal pass-through funding if available, and the program must allow qualified residents to purchase qualified plans on the individual exchange. The amendment also alters the items that must be included in a required report to the General Assembly. I move the amendment and the adoption of a favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, Chair recognizes the senator from District 4. On the amendment, any discussion on the amendment? Any objections to the committee amendment? Without objection, the one committee amendment is adopted. Question now on the amended report. Chair recognizes the senator from District 4.
If the floor leader would yield for a
Will
couple
the floor
questions.
yield? Senator may proceed.
Thank you, Senator. So I just have a couple questions. I'm looking at this bill, and I see that it talks about a qualified resident. And really, a qualified resident, as I look at it, as long as they live in the state and aren't incarcerated, it's really anybody, regardless of if they're a citizen, not a citizen, here legally, illegally, anything of the like. Is that pretty accurate?
For the most part, the bill here, though, gives us the authority to submit a waiver to the federal government to make sure that undocumented individuals have an opportunity to purchase insurance.
So the irony is that they're not a qualified resident. We're making a nice word, but they're really not a resident.
Currently, undocumented individuals cannot purchase from the exchange. Now, they can purchase insurance from the commercial market, but as it is right now, we would require a waiver from the federal government in order for them to purchase insurance from the exchange.
I appreciate that. You know, I just find it, and I guess I'll just, on the bill, Mr. President, I find it ironic that, you know, here we're putting nice language in that talks about being a qualified resident and the health care and providing health care for essentially anyone's here, regardless of their immigration status, legal, illegal, or otherwise. And we've got this body, we've got state employees that we made a promise to. We made a promise to them for their continued health care, prescription health care, and we're taking that away now. A promise made by this body should and is always should be a promise kept. And we're failing our state employees by doing this. By, you know, I think that we should, you know, we're taking that away from them at this time. They're out there advocating, asking us to help them because their rates are going to go up, and we're going to have a plan like this that says qualified resident, which ironically they're not. So, Mr. President, I would ask for a special order of this bill. I'm looking to, for the purposes of an amendment.
Let's see. Okay, senators moved to special order the bill. Let's hear from the floor leader.
Thank you, Mr. President. I just want to clarify one thing. We talked a little bit about state retirees, and obviously our retirees here in the state of Maryland are having more burdens put upon them. That's not this bill, right? This bill is essentially giving undocumented individuals a right to purchase their own health insurance, many of which are paying a great deal, millions and millions of taxes here in the state of Maryland already. And so this is simply giving them the right to buy their insurance. Now, it's also, because they're undocumented, it doesn't allow them to have the tax credits that everyone else is qualifying for. So this is essentially giving people the right to purchase insurance. In many cases, there are people that are part of the family unit that are legal residents. This gives those individuals also an opportunity to have one level of insurance coverage. And so I just wanted to make it clear that this one has nothing to do with our state retirees. I think there's a lot of misinformation out there in the community about this. This is essentially giving individuals the ability to purchase health care. I'm sorry.
Apologize.
And then I think on the question of special order, I think I'm looking for up, down, no. Yeah, I think that's a very reasonable request to special order. Is it one day, Mr. President, was the request for?
I think it was, I believe so, a special
Just
order.
until tomorrow. Just to give me the time to look through the bill and for an amendment. Thank
That's
you.
reasonable, and thank you so
Appreciate
much
it.
for the question. Thank you, Mr. President.
All right. Any objection to the motion of special order? Without objection, the motion carries. The bill will be special ordered to the appropriate time tomorrow. All right, let's go stick with finance. We've got report number 11. Clerk, read the first bill.
Senate Bill 559, Senator Bidle, Business Regulations, Household Good Movers, Special Fund for and Fees, favorable.
All right. Let's see. Chair recognizes the chair of the committee as the floor leader.
Thank you, Mr. President. So this is the Household Goods Mover Special Fund for Registration Fees. In 2019, I was actually the sponsor on a bill that required household good movers to register with the state. This was actually requested by the household good movers to the Maryland Motor Truck because of so many complaints. There's just pages and pages of complaints every year that goes to the Attorney General. So all this bill does is actually establishes the fund and puts it in a fee to manage the registration. It was something the prior administration would never enact the bill, even though it passed this body. So there are no amendments. There's no opposition at the committee hearing. I move the adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 559 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 648, Senator Ellis, Business Regulations, Contractors, Subcontractors, and Brokers, Prohibited Conduct, favorable with 2 amendments.
Recognize the bill sponsor as the floor leader.
Yeah. Thank you, Mr. President, colleagues. Every year in Maryland, there's over $60 million in wage theft. Let me say it again, $60 million in wage theft every year, mainly in the building trades industry. I can vouch for this number. It happened in my own district. A contractor working in renovating a school, a major project, was privately sued for wage theft and was found guilty and had to pay back to the one employee over $200,000. And this bill, Senate Bill 648, prohibits a person convicted for any kind of transgression in wage theft to be barred from doing contracts in Maryland for a period of 5 years. This bill also is amended to add contractors and subcontractors to the prohibition. Needless to say, no one came forward to oppose this bill because no one would come and say they're in favor of wage theft in Maryland. So, Mr. President, I move for the amendments and the adoption of the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 648 is hereby ordered printed for third reading. Chair recognizes the senator from the 23rd.
Thank you, Mr. President. So nice I have to say it twice. Colleagues, we are joined by the Student Government Association of St. Pius X Regional School from Bowie, Maryland. I want to ask them to stand up there in the gallery. We're joined by Miss Olivia, who's the SGA president, as well as Miss Kathleen McGinnis, who provides their guidance. We thank them for coming down to Annapolis today and hope they have a great day. Please give them a round of applause.
Excellent. Welcome, welcome, welcome. All right. Yes, Chair recognizes the senator from the 22nd District.
Thank you, Mr. President. I would like the body to help me recognize the students of Eleanor Roosevelt High School, their government and politics class that is here today. They're also with their teacher, Amy Littman, just to see how we work here in the Senate and in the Maryland General Assembly. Please give them a round of warm Senate welcome.
Welcome, welcome to the students from Roosevelt. Welcome, welcome. Thank you all for joining us today. Recognize Senator from District 40.
Thank you, Mr. President. I believe in the gallery are students and staff from Mother Mary Lane. Are they here? Are they behind me? I just can't see them.
Yep, right behind us.
All right, thank you, Mr. President. Colleagues, please join me in welcoming the students and staff from Mother Mary Lane. It's the first Catholic school built in the city of Baltimore in more than 50 years, named after very own Mother Mary Lane, who was an activist in her own right. Please join me in giving them a warm welcome this morning.
Welcome, welcome, welcome. Thank you all for joining us. All right. Any other introductions? If not, let's go ahead and keep going with Finance Committee. Report number 12. Clerk, read the first bill.
Senate Bill 215, Chair, Finance Committee, Small Minority and Women-Owned Businesses Account Alterations, favorable with one amendment.
Recognized Senator from District 40 is the floor leader.
Thank you, Mr. President. As amended, Senate Bill 215 is a departmental bill that alters the eligible uses of the small minority and women-owned business account to allow grants of up to $10,000 in conjunction with a loan. The amendment maintains the ability for eligible fund managers to provide investment capital to eligible businesses in the state. There's no fiscal impact. There was no opposition at the committee hearing. I move the amendment and the adoption of a favorable committee report.
Floor leader moves to the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 215 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 457, Senator A. Washington, Maryland Technology Development Corporation, Equitech Growth Fund alterations, favorable with one amendment.
Recognize the bill sponsor as the floor leader.
Thank you, Mr. President. This bill alters the permissible uses of the Equitech Growth Fund at TechCo and makes changes related to the mandated appropriation. There's just one amendment that moves up the effective date, putting it in the same posture as the House bill currently. There were no oppositions. I move the favorable committee report. Thank you.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 457 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 634, Senator Klossmeyer, Maryland Technology Development Corporation Authority, favorable.
Recognize the bill sponsor as the floor leader.
Thank you, Mr. President and members of the Senate. Senate Bill 634 explicitly authorizes the Maryland Technology Development Corporation, also known as TEDCO, subject to a written agreement to provide administrative support and services to certain business entities and receive compensation for their support and services. There are no amendments. There's no fiscal impact. There was no opposition at the committee hearing, and I move the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 634 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 746, Senator Gazzone, Winery and Vineyard Economic Development Grant Program modifications, favorable.
Recognize the senator from Carroll County as the floor leader.
Thank you, Mr. President. Senate Bill 746 removes the September 15th application deadline and December 15 grant award deadline under the Winery and Vineyard Economic Development Grant Program, which is housed in the Department of Commerce. Senate Bill 746 modifies the period during which a qualified capital expense has to be paid or incurred by an applicant for the purposes of calculating the grant amount. There are no amendments. There is no fiscal impact on this good bill, and no opposition in the committee. I move the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 746 is hereby ordered printed for third reading. Let's go to Education, Energy, and the Environment. Report number 15. Clerk will read the first bill.
Senate Bill 78, Senator Sidnor, Education, Baltimore County School Board Nominating Commission, Records and Meetings Requirements, favorable with two amendments.
Recognize the senator from District 10 as the floor leader.
All right, thank you, Mr. President. This bill requires that a meeting of the Baltimore County School Board Nominating Commission must be open to the public if it involves the interview of, deliberation about, or action on a candidate for appointment to the county board. The bill also specifies that notwithstanding any other provision of law, an application to the commission for appointment to the county board or any record requested or received by the commission from an applicant is not confidential and is subject to disclosure under the Maryland Public Information Act. There are two committee amendments. Amendment number 1 is technical. Amendment number 2 strikes the provision regarding the non-confidentiality of applicant records and requires the commission to publish the name of the candidate on the commission's website before interviewing any candidate. And instead of requiring certain meetings of the commission be conducted as a public meeting, requires certain meetings to be recorded and requires that recording to be made available for public inspection within 48 hours after receiving a request for the recording. There is no fiscal impact. I move the adoption of the 2 committee amendments and the favorable committee report.
All right, floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 78 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 353, Senator Simon Ayer, Confined Aquatic Disposal Task Force, favorable with 1 amendment.
Recognize the bill sponsor as the floor leader.
Thank you. This bill establishes the Confined Aquatic Disposal Task Force and specifies its duties and responsibilities. The bill takes effect July 1st, 2024 and terminates December 31st, 2025. There was 1 amendment that alters the membership and duties of the task force. I move the favorable report and committee amendment.
Floor leader moves for the adoption of the 1 committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the 1 committee amendment is adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 353 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 527, Senator Kelly, Community Colleges Contraception Access Requirements, favorable with 2 amendments.
Recognizing Chair of the Committee is the floor leader.
Thank you, Mr. President. Last year, Mr. President, we passed a bill requiring Maryland's 4-year public universities in consultation with students to implement a reproductive health service plan. It was a broad bill. It included access to over-the-counter contraception from either the student health center, retail establishments on campus, or vending machines. As I pointed out last year, the lack of access to contraception has negative impacts on college students when they have unintended pregnancies. Specifically, we had testimony from one group, the Progressive Policy Institute, reported 38% of college dropouts are a result of pregnancy. Another study, we had testimony from another organization, says 61% of women who have a baby drop out before they get their degree. We had other testimony. The Maryland Coalition Against Sexual Assault indicated that 1 in 5 women report sexual assaults during college, so which brings us to Senate Bill 527. Many of these access to contraception issues are even more pronounced in our community colleges. Again, last year's bill only applied to the 4-year public universities. Within the community college setting, oftentimes they don't have healthcare centers. In fact, of our 22 community colleges, only 7 have healthcare centers. The dropout rates in our community colleges are even higher than our 4-year institutions, and those dropout rates are much higher when it comes to unintended pregnancies. And I would also add a high population of students at our community college come from lower income communities and face greater access to healthcare services broadly, including contraception. So again, last year's bill only applied to 4-year public universities. What this bill does, and it's much narrower, applies only to our community colleges, which were not included in last year's bill. The only thing this bill does is require each community college, in consultation with students and student organizations, to develop a plan to provide students with access to over-the-counter contraception. That's a plan that has to be implemented by August 1st, 2025, through the student health centers, campus retail establishments, vending machines, which is already in place at 3 of our institutions, 4-year institutions, or any other methods that provide students access when on campus. There are also a number of reporting requirements in the bill, from MHAC back to the General Assembly, et cetera. I want to make this point. The Maryland Association of Community Colleges submitted testimony in strong support of this legislation. We do have 2 amendments. The first amendment's technical. The second amendment establishes a single date by which the community college must develop and implement that required plan. I noted that earlier. That's August 1st of each year. And with that, Mr. President, I would move the adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Yes, Chair recognizes the Minority Whip on the amendments.
Thank you, Mr. President. Could the floor yield for a question?
The floor to yield. Senator
Yes,
may
sir.
proceed.
Does this specify, it specifies different ways that it can be delivered. Does a vending machine meet the requirement?
Yes, in fact, that is specifically enumerated as one of the ways in which access to contraception can be accomplished. And I would also note, in the community college setting, you don't have folks aren't living on campus, and I would say vending machines are already in place as a result of last year's bill at several or four-year institutions. So this is just extending, and again, a narrower way. Last year's bill dealt with much broader reproductive health plans. This is specifically over-the-counter contraception approved by the FDA, and yes, vending machines would be one possibility here.
But the issue of 24-hour access, so to the best of my knowledge, we don't have any community colleges where anybody stays the night. So I just think of the community college I'm most familiar with, they lock the doors at a certain point. So
Okay, that was last year's bill talked about 24-hour access. This is a community college where a lot of the students are not on campus. The 24-hour access, this is only in play by the terms of the bill during campus when the students are there. So this does not have a provision dealing with 24-hour access. Let me just double check, but that was last year's bill. There's no reference to 24-hour access. This is during campus hours when the students are on campus. But again, vending machines and access more broadly is the point of the bill. We did it last year for our four-year public universities. We're extending that portion of the broader bill from last year to the community colleges.
Okay, I think there may be another question coming, but is there any provision here on costs and that sort of thing? 'Cause
Yes.
we obviously have a situation where community colleges are losing funding.
Sure.
Also, if they all support it, I'm not sure why we need a bill, but.
Okay, that came up, not surprisingly, and the cost is extremely minimal. So a vending machine, we had testimony in the committee, somewhere between $1,200 to $2,500 for a vending machine. If you look at the fiscal note, it says the impacts on the university and the community colleges will be minimal. And if it were more than that, I suspect the community college would have come in and raised some concerns. They did not. They did the exact opposite, which was to say we strongly support this bill.
Okay, thank you. I think there's maybe another question coming, so thank you very much.
Thank you, Senator. All right, Chair recognizes Senator from District 6 on the amendments.
Thank you, Mr. President. We yield for a
The
question.
floor to yield. Senator may proceed.
Yes, sir.
I think you kind of answered it, but I still believe there's something I believe is a question that we've said that, of course, there's no dorms.
I'm sorry?
There's no dorms.
Correct.
There's no housing.
Right.
Okay, so they're not staying there, living there. They're part, I guess, of the system that take classes for the community colleges. So why really is this necessary?
Well, I mean, these are college students, and by the way, I would say one of the leaders in this space is the sponsor, if she wants to weigh in on this, why this is needed. I mean, I would say that, unintended pregnancies is a big problem on the college campuses, whether it's four-year public universities or community colleges, and I would just say the access, you either support access to contraception and wanting to prevent unintended pregnancies, or you don't. If you don't want to go that route, you can certainly vote red on this bill. But I think that the data is suggesting that we do everything possible to provide the students with access to over-the-counter contraception. Again, this is FDA approved, so there's no safety issues. This has been vetted. And, so it's a policy call. We did it last year for the four-year institutions, and this bill extends it to our community colleges, which, by the way, as I said earlier, the student bodies there don't have necessarily the same access to healthcare services as the students who attend our four-year public universities. That's another reason or rationale for the bill. And so when they're not on campus, they may have be uninsured at a higher rate. They may have other, obstacles to accessing contraception. Whatever the case may be, that's kind of the premise of the bill.
And understand unexpected pregnancies. I just believe this is just another avenue where we're putting something out there that I believe wouldn't be necessary for those that are not staying at a community college. it's just for classes and not having dorms. That's just my only reason.
I'll
Mr.
just come back. The community colleges themselves.
Senator, if we could just let the senator.
Yeah. Okay.
And
Yes, sir.
I'm just saying that I possibly, when the time's right, Mr. President, I would maybe like to look at it in more. Maybe it might have an amendment for special order if that's the right time, for the right time.
Well, now would be the perfect time for the motion is to lay the bill over, if that would be.
If that's possible, Mr. President.
All right. Senators move to lay the bill over. Motion is in order. The bill and the amendment
Thank
will
you,
lay
Mr.
over
President.
under the rule. All right. Clerk will read the next bill.
Senate Bill 592, Senator Zucker, Maryland Achieving a Better Life Experience ABLE Program Materials for Individualized Education Program Meetings, favorable with 2 amendments.
Recognizing Chair of the Committee is the floor leader.
Thank you, Mr. President. This bill deals with the ABLE program, which many of you are familiar with, a really fantastic program that allows individuals with disabilities to save for their futures on a tax-deferred basis. All this bill does is it requires the state treasurer to develop written information materials about the ABLE program, which must be distributable electronically or by hand, and provide those materials to the State Board of Education and local boards of education for distribution to parents during individualized education program meetings as specified. One of the reasons for the bill is, although this is a tremendous way to save for the future for qualifying expenses, the participation rate is nowhere near where it needs to be. And I think we have a majority of eligible folks in this state do not take advantage of the ABLE program, so this education tool is, I think, very important. Two amendments. Amendment number 1 is technical and adds co-sponsors, and amendment number 2 requires the informational materials about ABLE be provided at a student's Section 504 plan meeting, similar to the requirements for IEP meetings. So that's basically what the bill does. I move adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 592 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 762, Senator Kagan, Excellence, Maryland Civic Excellence Program established, favorable with 1 amendment.
Recognizing the bill sponsors, the floor leader.
Thank you, Mr. President. Colleagues, last year, the good senator from District 5 had a bill that was similar to this that we passed unanimously. Over the interim, he and I worked on this, and this basically continues in the Moore Miller administration's commitment to service and volunteerism and making sure that our young people are engaged in community and educated about the value of being connected to their community. This bill would set up a volunteer program for middle schools and high schools to recognize students who focus on civic education and offer them a seal on their diploma, a cord on their graduation outfit, or whatever. 11 other states have already done something very similar to this. The Secretary of the Department of Service and Civic Innovation thinks this works really well with our service year option. It passed unanimously. There is one modest amendment that just sort of tweaks the bill as it was drafted. So I move the committee amendment and the favorable committee report.
Floor leader moves to the adoption of the 1 committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the 1 committee amendment is adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 762 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 835, Senator Hester, Environment, Delegated Authorities Well and Septic Program Permits, favorable with 1 amendment.
Chair recognizes Senator from District 9 as the floor leader.
Thank you, Mr. President. Colleagues, this bill is about improving the consistency and speed of well and septic permits. The bill establishes a schedule for the local health department or county government to submit a well and septic permit data to MDE for review. There is 1 committee amendment which requires a study with the local health department and the Department of the Environment on the IT systems necessary for these permits. I move the 1 committee amendment and the favorable committee report.
Floor leader moves for the adoption of the 1 committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the 1 committee amendment is adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 835 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 879, Senator Klossmeyer, Shellfish Aquaculture Harvest Hours, favorable.
Recognize the senator from Lower Eastern Shore as the floor leader.
Thank you, Mr. President. Senate Bill 879 modifies a provision that prohibits an aquaculture leaseholder from harvesting shellfish between the hours of sunset and sunrise, so that the provision instead prohibits a leaseholder from harvesting shellfish outside the hours established by the Maryland Department of Natural Resources. Currently, harvesters are severely limited in the time allowed to work privately cultivated shellfish leases. This bill correspondingly requires the department, in consultation with the Aquaculture Coordinating Council, to establish by regulation the hours for harvesting shellfish within the leased areas. And the bill would take effect of June 1 of 2024. There are no committee amendments, and I would move for a favorable report on SB 879.
All right, floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 879 is hereby ordered printed for third reading. All right. Yes, Chair recognizes the senator from the Upper Eastern Shore.
Thank you, Mr. President. Just a quick announcement. I understand that the students and faculty from St. Michael's Catholic School are here today from St. Mary's County. The senator is not here, so I wanted to make sure they are recognized and give them a warm Senate welcome.
Welcome to those from St. Mary's. St. Michael's in St. Mary's. St. Michael's in St. Mary's. Very good. Welcome, welcome. All right. Yes, Senator from the 41st District.
Thank you, Mr. President. I'd like to wish a warm welcome to the students and faculty of Bnos Yisrael in District 41 on Park Heights. Please stand if you're in the gallery. Thank you.
Excellent. We have, maybe they were in and out, but we welcome them in absentia. Yes, thank you, thank you. All right, let's see, if we have one more report out of, let's see, are there any other introductions before we jump in? No? Okay. Report number 16, clerk will read the bill.
Senate Bill 1, Senator Augustine, Electricity and Gas Retail Supply Regulation and Consumer Protection, favorable with 2 amendments.
Chair recognizes President Pro Tem as the floor leader.
Thank you, Mr. President. Colleagues, Senate Bill 1 is a significant consumer protection and really a cost of living bill for the people of the state of Maryland. And so I'm going to ask you to bear with me as I go through this bill and what's behind it. First of all, this is about retail energy supply, power, which is really a basic necessity that we all depend on, and it's why we actually treat it very differently, because we must have our power. And I just want to start too by just sharing, because we don't always think about our electric bill and what our electric or our power bill has. And our electric and power bill has basically 3 different parts. The first part really deals with the regional network. That regional network is called PJM, and that regional network makes sure that we have consistent power on our grid, and it moves that around and makes sure that the lights are always on, basically. And then we have our local network, which are our utilities, which we are all familiar with, which really take care of that local distribution, that which comes to our homes and to our businesses. Now, what is a part of that, a third part of this whole thing, is the actual energy itself. And that's that energy supply. And this is a separate part of the bill that you will see. And in 1999, there was a move across the country, actually, because the cost of the energy, just the energy itself, was so expensive, and it becomes so expensive that the thought was that we would employ competition and open up that market to competition in the hopes that that would drive down cost. and that would make sure that we have a lower cost based on the competition being in there. Unfortunately, it just has not come to pass over the course of the last 25 years. It has actually not saved Marylanders money, and in fact, while there were 26 states that originally at that time, when the federal government allowed for this, had that deregulated market, that is now down to 12 because it has not worked basically across the board. Now, I will share with you all that before my introduction to retail energy suppliers really happened in my neighborhood, walking, canvassing, going and talking to my constituents. And what I would find is there would be these folks walking around with a little name badge on that was kind of like a fake utility badge. It may have 3 digits and a question mark or something like that. And they would come up to me and say, hey, what are you out here pushing? What are you trying to do out here? I'd be like, what are you talking about? I'm not out here pushing anything. I'm out here trying to just talk to my constituents. And they would hurry and scurry away. Now, what I learned was that these were folks who were out there talking to my neighbors, our hardworking neighbors, and trying to basically change their energy supplier. What they were trying to do is they were trying to knock on their door, and the only thing that they were trying to do is get their customer number so that they could then change to the energy supplier such that they would be the energy supplier. Now, some of you all may not get that in your neighborhoods and things like that. You also might receive it if you may get it in the mail. Now, we received one in my house just like, a few weeks ago where there was an offer of 500 miles in order for us to change over to another energy supplier, but we chose not to actually do it. Now, what the thing is, when you do that, and they provide to you like a teaser rate, and they'll say that it's going to be a little bit less, but the fine print doesn't tell you that they are in control entirely of that price, and that they will and do change that price at a real, much higher cost for the people of the state of Maryland. Now, what they also will do, what we find is that they will, when they're doing that door-to-door and other things like that, they will also slam our folks. They get that customer number, and they will just change them over to their supply without even knowing it. And this is targeted. This is targeted into some of our zip codes, into some of our lower income neighborhoods, and it is absolutely intentional. And the scope of this is significant, colleagues. The scope of this is over 300,000 customers who annually pay $150 million above what it would otherwise cost if they just simply signed up for their power from the utility, the basic utility. That is just for the electricity. There is also an additional $50 million above just what you get for just regularly signing up for 170,000 customers in the gas space. So those who are doing it with gas. This is the scope of what we're doing. Now, these are not my numbers. These are numbers that the retail energy suppliers have shared with the Department of Energy. It's on their website. You can look at it. You can see what that is. Now, what this piece of legislation does is says that we no longer are going to stand by while Marylanders are being forced to pay this additional money. Now, a couple of years ago, we started on this journey. There was Senate Bill 31 in 2021. That was legislation by a senator from Baltimore City and Baltimore County that said that retail energy could not be sold to people who received energy assistance. And the rationale for that, although we did also at the same time, we allowed for the PSC to be able to accept proposals to create offerings for people who are on energy assistance. Now, the purpose for that was because what we said was it was not a good deal for the people of the state of Maryland to be investing money through these subsidies for people and then having to pay extra above what would be the default price. Now, that passed through this chamber with a vote of 40-6, bipartisan, strong support for that piece of legislation on the rationale, again, that it was going to save money for the people of our state. That brings me to now, and this is really just a continuation of that, and we have collaborated with stakeholders, incorporated many of their suggestions The largest of which will be different from originally introduced, is that we have removed the commercial folks from the bill because the commercial people are more sophisticated and able to negotiate for rates in ways that residential customers simply don't. Because I, like you, I'm not looking at that bill every month when that price may be going up way beyond what it should be. Now, what the bill does is it really does three significant things. Number one, it creates a general market with primary guardrails of price to not exceed the 12-month trailing average of the default rate that I've been talking about for both electricity and gas. Now, we also with this piece of legislation create a green market. And what this green market provides is a framework for individuals who want to purchase renewable energy and renewable energy credits that may be above that default price to do so while taking lessons from this existing market to make sure it's fair. We put on guardrails that incorporates the PSC in the process to ensure that that price is fair, transparent, and based on actual renewable energy, and it bans those predatory practices employed within the market in the past. The third real important part that we really do with this piece of legislation is we create a licensing scheme, penalties, training, and we also have education, which incorporates some of what will be in Senate Bill 918 from the senator from the 10th District. And we have reporting within that framework that allows for greater transparency and accountability. Now, colleagues, this bill alters regulatory requirements for the marketing and sale of electricity and gas by retail suppliers and utilities. The bill must be construed to imply only prospectively and may not be applied or interpreted to have any effect on or application to any electricity supply agreement or gas supply agreement that is in effect on or before December 31st, 2024. The bill takes effect July 1st, 2024. There are two committee amendments. The first committee amendment is technical. The second committee amendment makes several substantive changes to licensing, penalties, and marketing disclosures. First, the amendments exempt commercial and industrial customers from compliance with additional requirements for licensing and marketing disclosures. The amendment establishes a license with a 3-year term for energy salespersons and energy vendors and limits residential supplier licenses to 3 years. The licensing of energy salespersons and energy vendors must begin on July 1st, 2025. The amendment also modifies the Retail Choice Customer Education and Protection Fund to accommodate trainings for suppliers, salespersons, and vendors. By December 31st, 2024, the Commission must develop a comprehensive training program for entities in the retail market. As amended, an electric cooperative is permitted to advertise, market, and promote standard offer service, the default service. Gas and electric investors-owned companies may provide customer education and receive rate recovery. The amendments further prohibit the price of retail supply from being offered at a price higher than the trailing 12-month average of the company's standard offer service rate. However, green power products may exceed this price cap. The amendment allows auto renewal in certain circumstances and reauthorizes a supplier to impose certain fees on a residential customer. The amendment requires marketing disclosures and pricing oversight if residential suppliers offer green power products. And by 2035, at least 50% of renewable energy credits purchased to support a green power claim must be generated in the PJM region. The amendments provide a procedure for licensing expiration, create new position identification numbers within the Public Service Commission, and raise the Commission's assessment on electric companies and suppliers to fund the new mandates. Now, while there is a fiscal impact, that fiscal impact is taken care of by the additional revenues from the special fund that we have incorporated into the bill. Mr. President, I move adoption of the two committee amendments and the favorable committee report.
Floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Chair recognizes the minority leader.
Thank you very much, Mr. President. If the floor leader would yield for questions,
Senator
please.
may proceed.
And just to make sure the body knows, the amendments are 29 pages. So there are an awful lot of amendments that are in the bill itself. Just to go back on what you were briefly talking about, General Assembly did make a move several years ago to go to a deregulated market, and that's where we currently are. And I know that over the years, we have tried to build a robust deregulated market. In fact, the chairman of EEE and I had worked together on several bills that dealt with a more robust website. We modeled it after Pennsylvania. We wanted to make sure that we could have true customer choice in what we were looking for. We talked about quicker interconnects that we did. We also looked at some of the protections that you talked about. We wanted to make sure that there was some protection of the customer number, and we also looked at making sure those that were on energy assistance were not necessarily making poor decisions and using government money the wrong way. So I think we've done a number of things. What's interesting in the way that you've described it, where we are right now, and certainly I believe that it's going to go back to a re-regulated market if we're here. I think that we're taking away too much opportunity for retail choice, and you described it in your guardrails that you talked about. The first guardrail was that retail choice could provide products so long as they trailed there was a cap on it for a 12-month trailing average of the SOS. So in other words, any products that they offered had to be less than SOS.
Yes.
Correct? Yet at the same time, we talked about green power, and we're trying to move green power out there, and he said, that's okay, the guardrails are they can be more than SOS, but PSC has to evaluate and make sure that those rates are still feasible, comparable, fair.
That's right.
Okay.
Yep.
So in doing that, so we've got two guardrails going down, we've got SOS in the middle. I'm interested in how, when you describe the 12-month trailing average, what that looks like with respect to how a retail energy supplier will have to price their power based on that. So can you explain what that 12-month trailing average is?
Yeah, absolutely. And just to be clear, this is not something that's not already in place and employed in New York, which they already are using this as a methodology to determine a price that in a retail energy supplier would have to work from. All it is this basic math. They're looking backwards. They're taking that pricing, averaging it out, and sharing that information. The PSC will share that information out with the retail energy suppliers, and their pricing will need to be less than that number.
Okay, but with respect to New York, I don't know if that's a great example anymore. I understand that retail choice program is crumbling there as well right now, and probably going to go away very quickly because of some of the things like this. Well,
Senator, I would suggest to you that it's probably that the people there are saving money now. And if they're saving money, and you call that it being crumbling, well then, I mean, that's more money in the pockets of hardworking Marylanders.
Just a reminder for everyone, if we could refer to senators in the third person, it depersonalize the debate. Senator, may proceed.
Standard office.
Certainly possible, but I'm not sure. With respect to 12-month trailing average, though, if they're having to look back at SOS prices, SOS is actually trailing by a 6-month already because of the auction process. So now you're really looking at prices that were, in a sense, almost 18 months ago, or the average of the last 18 months when this comes into play because of where SOS was designated based on the auction process, right? So I guess my question really is, rather than trying to figure all that out, why don't we just allow the retail energy suppliers to offer at or below SOS?
In essence, that would only be a small difference. To my mind, in essence, that's what we've already done, since it is below this 12-month trailing number. I mean, that there has to be a point at which you determine what the number is, and that's simply the way that we've set it.
Right, but if a retail supplier is advertising on a website right now, the way that they are advertising that number is because they've had to go back to this 12-month average. They've had to, I guess, clear that with the PSC, or there has to be some type of a notification that that's the right number. Why can't they just offer at SOS? I mean, why couldn't that be a choice for customers? They're not, in a sense, they wouldn't be charging above SOS, but just charge whatever SOS is at the time.
So basically, as I shared, the SOS price is a Obviously, as you mentioned, it's one that comes together through the process of auctions, in essence, but it is a fixed rate.
Right.
And so if the suppliers were to offer something that was 1 penny less, I mean, they would be able to do that. Again, I understand what you're saying. This is simply establishing where the trigger point is. And furthermore, while you are correct that there is a trailing that occurs with regard to SOS, this will be happening in essence in the same way. So it is in fact 12 months. It's not the 18 that you talked about, because it will incorporate the same information from the SOS process.
Okay. I'm not sure that a retail supplier can offer just a penny less. I'm not sure if that would fit within the guardrails of the 12-month trailing average.
What we have set up will be managed by the Public Service Commission. We've given them, and they will have the responsibility to manage and make sure that everyone is living up to our legislative intent.
Okay, that's interesting to know. Okay, I'm just going to go on the reprint. On page 17 of the reprint,
yep.
It talks about allowing co-ops to advertise for the SOS. In fact, it says that electric companies may not recover the cost, but co-ops can recover the cost for advertising and marketing SOS product.
Yes.
Why did we allow the co-ops to recover costs there?
The co-ops are in a different posture than the investor-owned utilities. The co-ops are owned by their members. Therefore, there isn't, in essence, a marketing cost that would then be tied to a profit. The marketing cost would be borne by the members, who all benefit from it, and that was our rationale.
But is it important to advertise SOS?
What they are doing is sharing information about the offering that they have. They are particularly interested in a green offering that they have, that they would like to be able to communicate the benefits of to their members. This gives them the flexibility to do that, whereas the way that it was structured in the past, they weren't able to communicate about it at all.
Okay, so that's interesting that green power is brought up. And again, you mentioned previously that green power can be sold for more, can be a higher rate than SOS, correct?
That is correct. We know that green power, part of the rationale for that is that we have, as a policy statement, made investments in this transition to renewable energy. That includes green power. And so there are attributes of green power, renewable energy credits, which we know and we've established a certain value that we have for those. This acknowledges that, which can then therefore make that cost, the power cost more. This acknowledges that while also encouraging the development of those green energy resources.
So you're right. It's correct. That's been discussed several times that because of the RPS that we have and the requirement to purchase RECs, obviously that drives potentially green energy costs up.
Yes.
On page 24, so respect again to green power, the definition of green power was struck from the bill, 7-707. I'm just wondering why that was struck, and is green power and renewable energy equivalent?
We have a definition of green power which includes the underlying power itself, the actual energy, and it also includes the renewable energy credits that could be associated with it. And that is how we are defining green power in this piece of legislation.
And if I missed that definition, I'm sorry. I just saw where it was struck out, but then I saw, I'm just wondering if it was put back in somewhere else, what that definition is, or is it done through a series of lines?
Can you tell me your question?
My question is, the definition of green power was struck. Was it replaced somewhere else?
It is not put back in because we have given flexibility to the Public Service Commission as they are adopting the regulations that will construct the market to be able to make that assessment.
Okay. On page 25, and again, this was something I know the advocates had worked on for a while, and we've had conversation about this as well too. But when a customer buys green power or renewable energy, what are they really buying, right?
They're buying renewable energy credits.
They're buying credits. And,
Yes.
and so the bill as originally drafted had a disclaimer that says if you purchase this energy plan, you are agreeing to purchase local utility distribution grid electricity that is paired with renewable energy credits in an amount sufficient to match the percent of green power electricity in your contract. And so I think everybody understands that. What they're really saying is you're buying an attribute.
Yes.
Right? You're not necessarily buying
That is
green
correct.
power. And
Yes.
so I think the advocates wanted to make sure that that was very clear to customers. That,
Yes.
that again, this is a consumer protection bill, that you're not out there thinking you're buying something when you're not. Now, that was removed, and let me see if I can get through what was added, okay? This is the disclaimer that is added. We deliver energy through the purchase of renewable energy credits, RECs. A REC represents the social good that accompanies 1 megawatt hour of renewable energy generation. RECs may be sold separately from renewable energy itself. Renewable energy and RECs may be sold to different entities. The purchase of a REC does not indicate that renewable electricity itself has been purchased by the entity that purchased the REC.
That is absolutely as clear of a disclosure as it is a very complicated matter, but that actually does very clearly define what it is, and that's the hope.
I would think that most people think that that is so much more confusing, that do not understand what that disclosure is compared to the language that was in the bill. And so my question is, if we were really trying to make this about consumer protection and making sure that people are not buying something they're not, why was very clear language taken out in this, this paragraph that talks about RECs and things of that nature? Why was that? Why was that change made?
It was added because it is a more complete, it's far more complete explanation of what the process is, and that's the reason.
Okay. It makes it appear as something is trying to be hidden from the customer here, because again, I think that the original language that the advocates brought was very clear, and many people are going to gloss over this and not understand that at all. But let me ask just a couple quick questions. Throughout the bill, the Department of General Services and community choice aggregators were exempt. Can you explain why those were exempt?
Yes, we, as a policy decision, we will have offshore wind from DGS, and so that was the purpose for that. And the aggregators, there are aggregators, including one in Montgomery County that's that's functioning, that we wanted to just clarify in the definitions that they were not included as a retail energy supplier.
Are there any guardrails on what they can charge for electricity, or is the expectation that they'll be charging above?
Those are,
SOS?
the one has to do with purchase power agreements and would still be negotiated between, obviously, the state would incorporate the Public Service Commission. Same thing with the aggregators. They are subject to Public Service Commission in other venues, which is the reason why they are not, it wasn't appropriate for them to be incorporated into this.
Again, we talked briefly last night, but Does this bill prohibit multi-year contracts if the initial rate begins above SOS?
There are restrictions on multi-year contracts in the general market. Yes, so there are restrictions on multi-year contracts for retail, not obviously for commercial.
So commercial can still, if they're savvy enough, can still benefit from retail choice and decide that they may want to lock in a rate, because who knows what the Maryland General Assembly might do to drive electricity prices up at some point in time. Finally, just in respect to auto renewals, they are allowed or not allowed specifically related to community solar power purchase agreements, energy service contracts. Are we allowing auto renewals there?
The auto renewals actually, and this was one of the concessions that we made, were allowed under the green power claims in the retail market, and the other ones are not subject to, the other areas that you talked to are not subject to this bill.
So any current purchase power agreements that are in place, community solar,
they're not subject to this bill.
They're not subject to this at all. Okay, and then finally, again, going back to where we are in a deregulated market, obviously the goal there is to try to drive down electricity costs in a deregulated market. And appears that the General Assembly is going to believe that that has not worked out. We're going to move more towards re-regulated. That's going to take competition away. I believe without competition, we're going to see higher SOS prices down the line. And is there any guardrails to show that, based on the changes that are going to be made in Senate Bill 1, that prices that are going up could be a result of this bill? And are there any type of reporting requirements from the PSC or anybody to get back to the General Assembly and say that we've seen a consistent uprise in SOS costs that could be a result of moving towards a re-regulated market?
The SOS, which is simply a pass-through for the most part, with some additional charges that are on it, is driven by the suppliers who bid into that market, and that is obviously the much larger market that exists for power. And so therefore, by definition, there really isn't a cost that is above the market rate, unless we create, which was created in 1999, a sub-market, as it were, which allowed for folks to actually charge above what was the market rate for the large SOS auctions that we already have. We, as a General Assembly, clearly, through the Public Service Commission and through the PJM, are able to monitor and track the SOS, the retail energy, which we will continue to be able to do in the ways that I articulated earlier. These things are already shared with the Department of Energy. And as I've said all along, these retail energy suppliers who are able to save Marylanders money will be able to continue to do that, and that will be reported in the same way that it is reported now.
Okay, I appreciate that, and we'll certainly keep our eyes on where the price of SOS goes over the next numbers of years. So I appreciate all your responses. Pleasure to chat with you. Thank you very much, Mr. President.
Thank you, Senator. Complicated issue. Good questions. All right, any further discussion on the amendments? Any objections to the committee amendments? Without objection, the committee amendments are adopted. Question now on the favorable report.
I was going to ask for a layover when the amendments are still up there, but if not, can I ask at least for a special order until tomorrow?
Do we have any amendments currently drafted? Senators requested the special order.
That's fine. Yeah.
Okay. Any objections? Any objections from the floor? Without objection, we'll special order the bill at the appropriate time tomorrow. All right. Let's see. Let's go to judicial proceedings. Report number 11. Clerk will read the first bill.
Senate Bill 273, Chair, Judicial Proceedings Committee, State and Local Correctional Facilities, Operational of Unmanned Aircraft Image Recording and Delivery of Contraband, favorable with 2 amendments.
Recognize the senator from District 1 as the floor leader.
Thank you, Mr. President. Senate Bill 273, as amended, this departmental bill prohibits a person from intentionally operating an unmanned aircraft over a correctional facility to record images of a facility unless authorized to do so by the managing official of the correctional facility or the Secretary of Public Safety and Correctional Services. This bill also prohibits a person from using an unmanned aircraft to deliver any contraband to a person detained or confined in a place of confinement. A violator of either of these prohibitions is guilty of a misdemeanor or subject to a maximum penalty of imprisonment for 3 years and/or a $1,000 fine. A correctional facility must post signage warning of the bill's provisions on the exterior of the property in the area visible to the public. Now, this bill does have 2 committee amendments. Committee 1 is technical. Amendment number 2 modifies the prohibition of operating an unmanned aircraft over a correctional facility to record images. The bill passed. Be so much moved, the favorable with amendments, Senate Bill 273.
All right, floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. Just saw an article this morning about the Chinese Army just has a new drone that flies and looks like a falcon. So you don't even know, you can't even tell. It looks like a bird flying. Fascinating. Yeah. Fascinating. All right, on the amendments, any discussion? Any objection to the amendments? Without objection, 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 273 is hereby ordered printed for 3rd reading. We may have to have a bill about that for the senator from District 12, after the windows, the birth. No. Multi-year joke there. Sorry. Okay. Clerk will read the next bill.
Senate Bill 449, Senator Muse, Criminal Procedure Incompetency to Stand Trial, dismissal, favorable with 1 amendment.
Chair recognizes the bill sponsors the floor leader.
Thank you very much. As amended, this bill alters the time after which a court is required to dismiss a charge of first-degree murder or a crime considered sexually assaultive behavior against a defendant found incompetent to stand trial to the lesser of 10 years or the maximum sentence for the most serious offense charged. A victim or victim's representative has the right to petition the court for extraordinary cause to extend the time to dismiss a charge against a defendant. There's one amendment. It just strikes erroneous language, and so we move favorable the bill and the innocuous amendment.
All right, the floor leader moves to the adoption of the 1 committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the committee amendment is adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 449 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 486, Senator Hayes, Correctional Services, Maryland Correctional Enterprises Management Council, report, favorable.
Recognize the Vice Chair of the Committee as the floor leader.
Thank you, Mr. President. This bill requires the Maryland Correctional Enterprises Management Council to research the potential benefits of the state soliciting private enterprises to provide goods and services currently provided by MCE. Report's not due until July 1, 2026. There are no amendments. Mr. President, I move the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 486 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 510, Senator Hershey, corporations and associations, electric cooperatives, non-escheat, capital credits, favorable.
Chair recognizes the senator from the 42nd District as the floor leader.
Thank you, Mr. President. This bill references non-escheat capital credits, whatever that term means. Well, the bill fortunately defines what it means. Non-escheat capital credits are A, money due to any past member of an electric cooperative in retirement of capital allocated to the account of that member for amounts received and receivable by the cooperative in excess of the operating costs and expenses. B, money for which at least 5 years has passed since the credits were retired. And C, money that has not been claimed by the past member. So, the bill provides that these non-escheat capital credits held by an electric company may not be presumed to be abandoned property. The bill authorizes the use of them by the electric cooperative either to assist members of the cooperative or to make donations to nonprofit charitable organizations. There was no opposition to the bill. The vote of the committee was unanimous. I move the adoption of the favorable committee report.
Interesting issue. All right, floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 510 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 607, Senator Folden, Public Safety, Police Accountability and Discipline Summary Punishment, favorable with one amendment.
Recognizing the bill sponsor as the floor leader.
Thank you, Mr. President. This bill looks to close a loophole that was established through the creation of the MPAA in that, as amended, this bill would authorize the imposition of a summary punishment of a police officer for minor violations of law enforcement agency rules and regulations that does not involve an interaction between a police officer and a member of the public if the facts that constitute the minor violation are not in dispute, the police officer agrees to the facts that constitute the violation are not in dispute, and the police officer accepts summary punishment. There's one committee amendment which alters the circumstances in which summary punishment is available. Mr. President, I move for the adoption of the amendment and the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 607 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 624, Senator Carter, Task Force to Study Public Information Act requests made to law enforcement establishment, favorable with two amendments.
The bill sponsor potentially? Floor leader? Yes, chair recognizes the bill sponsor as the floor leader.
Thank you, Mr. President. This is an extension of a bill that we've previously passed, and it just gives this task force more of an opportunity to meet. There are two committee amendments. Amendment number 1 alters the membership of the task force. Amendment number 2 provides that a member of the task force serves at the pleasure of the person who appointed the member and requires the task force to vote regarding a code of conduct as specified in the amended bill. I would move the two amendments in the favorable committee report.
Floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 624 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 672, Senator Charles, Vehicle Laws, Automated Enforcement Citations and Notices Mailing Addresses, favorable.
Recognize the senator from Prince George's as the floor leader.
Thank you, Mr. President. This bill requires the citations and notices issued as a result of automated enforcement under the vehicle law be sent to the current mailing address on file with the Motor Vehicle Administration or the current residential address on file with MVA if a mailing address is unavailable. This bill was voted out with no committee amendments, and I urge a favorable report.
Floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 672 is hereby ordered printed for third reading. Clerk, let's see, does that do it for that calendar? It does. All right, let's go to number 12. Clerk will read the first bill.
Senate Bill 89, Senator James, Child Abuse and Neglect Reports and Records Disclosure, favorable with one amendment.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President. This bill, which resulted from collaboration with the state's attorneys and other stakeholders, requires public disclosure of information concerning child abuse or neglect if a child was in the custody of a local or state department or agency or foster care, is the subject of an investigation, report, or referral of a complaint received by a local or state department or agency, and suffered a fatality or near fatality, so long as the disclosure doesn't undermine a state's attorney's investigation or prosecution. There's one committee amendment to add back language that was in current statute that was erroneously omitted. I move for the adoption of the amendment and the favorable committee report. The bill was unopposed.
The floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections to the amendment? Without objection, the one committee amendment is adopted. Question now on the amended report. Chair recognizes the senator from District 40.
Thank you, Mr. President. Will the floor leader yield for a question?
Certainly.
Senator may proceed.
In the disclosure, what type of public information is being disclosed in these cases?
That was the language that we added back, and it relates to information limited to the actions or omissions of the local department, the Department of Human Services, or an agent of the Department of Human Services, which is current law.
Got you. And so they're disclosing non-identified information to the public in the aggregate.
Exactly.
Excellent. Thank you, Mr. President. Thank you.
All right. Question remains on the amended report. Any further discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 89 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 423, Senator James, Real Property Recordation Procedures, favorable with two amendments.
Recognize the bill sponsor is the floor leader.
Thank you, Mr. President. This technical bill seeks to improve the process of real estate closings by requiring counties and towns to coordinate and create a certificate of all the outstanding charges owed on real property 45 days before closing for a fee, and also requires the development of electronic filing of closing-related documents and the electronic payment of fees and taxes. There were two amendments. One was technical, and the second one deleted some erroneous language. The bill received a unanimous committee report. I move the adoption of the two committee amendments and the favorable report.
Floor leader moves for the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the favorable committee report as amended is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 423 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 465, Senator Kelly, Common Ownership Communities Electric Vehicle Recharging Equipment Act of 2024, favorable with two amendments.
Recognize the bill sponsor as the floor leader.
Thank you, Mr. President. This bill, which passed the JPR committee unanimously, just extends the process that this body established in 2021 for condo owners installing electric vehicle recharging equipment to co-op members. Of course, this would be at their own expense. It also extends existing procedures to electric bicycles and requires the Department of Housing and Community Development to include information about the program on its website. Amendment number 1 is technical, and amendment number 2 clarifies that insurance requirements and website posting requirements. Move for the adoption of the committee amendments and the favorable report.
Floor leader moves for the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 465 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 668, Senator Charles, Department of Human Services, Children in Foster Care, Luggage, favorable with 2 amendments.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President. This bill requires the Department of Human Services to provide new luggage to a child in foster care who is being removed from a household. By December 1 each year, DHS must report to the General Assembly on the number of instances which a disposable bag was used to transport the personal belongings of a child in foster care, and the reason DHS failed to provide the child with new luggage. And 2, the supply and inventory management procedures for the new luggage supply. DHS must solicit and accept gifts, grants, and donations of any kind and from any source to carry out the bill. There were 2 committee amendments. The first amendment adds sponsors. Amendment number 2 requires the Department of Human Services to provide luggage to children entering, moving, or exiting a placement. 2, it requires the department to take into account a child's age, mobility, personal items to be transported, and preferences when providing luggage. And 3, this forbids the department from using disposable or trash bags to transport any items of a child in foster care. This was a very, very complex bill that needed to be changed, Mr. President, and I'm glad that this bill came out unanimously with both bipartisan support. We all know we have to take care of the children of the state of Maryland, especially those that are going through some of the worst times in their lives when they don't have their families, and being treated like trash is not something that Maryland is going to ever stand for. So making sure these kids have access to luggage and they're not going house to house with black trash bags. This is a good bill, and I'm happy to have been the sponsor for it. So I'm going to ask that we move the amendments, and then I'll urge a favorable for the bill as amended. Thank you.
Thank you, Senator. All right, floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 668 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 669, Senator Charles, State Government Attorney General reports, favorable 1 amendment.
Back to the senator from Prince George's as the floor leader.
Thank you, Mr. President. It seems to be my day today. This bill, as amended, repeals the requirement that the Office of the Attorney General, OAG, annually publish its annual report and opinions of the Attorney General from the preceding year in a bound volume. Instead, OAG must publish the specified reports on its website. There is 1 amendment, and it strikes the modification to the reporting requirements of the Attorney General under the Maryland Defense Act. This bill was voted out unanimously. Now I ask that we, 1, move to accept the amendments, and then move to accept the bill as amended. Thank you.
Thank you, Senator. Floor leader moves for the adoption of the 1 committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the 1 committee amendment is adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 669 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Joint Resolution Number 1, Senator Kelly, affirming the Federal Equal Rights Act, or Federal Equal Rights Amendment, favorable with 1 amendment.
Recognizing the bill sponsor as the floor leader.
Thank you so much, Mr. President. Here in this first week of Women's History Month, Senate Joint Resolution 1 aims to fix a centuries-old oversight by moving us 1 step closer to finally adding equality for women in the U.S. Constitution. After a century-long campaign and ratification from the requisite 38 states, the Federal Equal Rights Amendment remains history's most popular but never actually recognized amendment to the Constitution. This resolution urges Congress to finally affirm the ERA as the 28th Amendment and the Biden administration to publish it without delay. This body, for good reason, rarely passes resolutions. I've been in the legislature for 14 years. I've never introduced one before, but sometimes they are warranted under unique circumstances. If you all remember, last year we voted unanimously to urge the General Services Administration to select Maryland for the FBI headquarters, and that worked. So hopefully this works too. The committee found that there was a unique set of circumstances to make this resolution warranted, and it earned a nearly unanimous, strongly bipartisan vote from the Judicial Proceedings Committee. For background, Maryland ratified the Federal Equal Rights Amendment back in 1972. That same year, Maryland voters affirmed our state ERA, which passed overwhelmingly with a majority in 23 of the 24 jurisdictions. As a reminder, the Maryland and Federal Equal Rights Amendment language is identical. It says, equality of rights under the law shall not be denied or on account of sex. That's all it says. It was introduced in Congress first in 1923 by Susan B. Anthony's nephew, a Republican from Kansas, and was reintroduced every year from 1923 to 1972, when it finally got the 2/3 vote and went to the states for ratification. Throughout the 70s, 35 of the 38 necessary states, including Maryland, ratified the federal ERA. This was a campaign led by some of my personal champions like Shirley Chisholm and Barbara Jordan, two amazing congresswomen. But ratification efforts stalled for nearly 40 years. And then what happened was in 2017, Nevada, in a bipartisan vote, became the 36th state to ratify. Illinois, in 2018, in a bipartisan vote, became the 37th state. And finally, in 2020, Virginia, with another very strongly bipartisan vote, became the 38th and final state we need to ratify the ERA. So with the 2/3 threshold met, this resolution says it's time to recognize the ERA in the U.S. Constitution and calls on Congress and the administration to take those steps. The amendment simply adds additional co-sponsors. I move for the adoption of the amendment and the favorable committee report.
All right. Floor Leader moves to the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion?
Mr. President.
Yes, Chair recognizes the Minority Whip on the amendment.
I'm wondering if I could ask the floor leader to yield for a question.
About the amendment adding co-sponsors? Or about the resolution? I think we're on the amendment,
Probably the
right?
resolution. We are on the amendment, so I suppose we should adopt the
Would
committee
you
amendment.
like to be a co-sponsor?
We'll see. It depends on how your questions go.
Well, I mean, we're drawing up another quick amendment. So if we could get, let's see, we can keep it going. We'll keep it on the report. So on the one committee amendment, any objections to the one committee amendment? Without objection, the one committee amendment is adopted. Chair recognizes the Minority Whip on the amended report.
Thank you, Mr. President. So, yeah, if I could ask I'll make a statement first and then I'll have my question. First statement is women deserve to be treated equally and fairly under the law. And I think we all agree with that. Can you tell me the old amendment or the amendment we're ratifying? I know there's some debate legally over whether it's expired or whatever. Can you tell me that it was strictly on the basis of sex, that sex should not be, there should not be any discrimination based on the basis of sex, correct?
So the language has not changed since 1972. This resolution is just referencing the amendment we already ratified in 1972 that clearly has the word sex in it. And it also is exactly the language that's already in the Maryland Constitution that all the voters in Maryland affirmed in 1972. So the language hasn't changed.
Is the way that we interpret the language changing? Has it changed since 1972?
Has the way we interpret the word sex changed?
Sex.
No, really not. I mean, when we were having these conversations in the 70s, one of the reasons that ratification efforts stalled was because there was a fear of something that was, I'm sorry? Oh, something really referred to as the lesbian menace, they would call it. There was a lot of fear of gay rights issues back in the 70s, and that was one of the things that Phyllis Schlafly's campaign against the Equal Rights Amendment pointed to. But the other things that it pointed to were women outside of the women in the workforce, outside of the home, women in the military, women participating in the economy. Those were the issues that were organized to sort of slow the momentum of the ERA. So while there was always fear that the word sex might lead to, I mean, I don't want to speak for others who have a different opinion, but I will say the word sex obviously is encompassing of concepts of gender roles. And that was the case in the 1920s and 30s and 50s and 70s and today.
I mean, I've read a lot about the 70s for the sort of the side that was opposed to things like the ERA. I don't remember gay rights being the main objection. I think it was more about concern about gender roles being blurred to the point where it was no longer unique. And there's also concerns about what there was concerns back then, right after the passage of Roe v. Wade and some of those things. I think that was probably a little bit more the main focus. But I guess reason people can disagree. Yeah. So. The way the amendment is currently written, is it going to be how you express your sex and how you identify with your gender, or is it going to be whether you are a woman or a man and there's equality? From your perspective, how do we interpret that now?
The Equal Rights Amendment is preventing discrimination based on sex. Does that answer your question? I mean, that's the exact language.
Okay, thank you very much.
Yeah.
Mr. President, I think I'd like to ask to special order this bill for the purposes of amendment for a day.
All right. Any objections from the senators? Move to special order the bill. Any objections?
Perfect.
No objections from the committee. All right. Any objections from the floor? Without objection, the bill will be special ordered at the appropriate time tomorrow. All right. Let's go to special order calendar 31. 31. I think we are ready for this one. Clerk will read the bill.
Senate Bill 125, Senator Lewis Young, Residential Property Sales, Contract Disclosures, Superfund Sites. Question is on the adoption of the one substitute amendment offered from the floor by Senator Lewis Young.
All right, the question is on the prior amendment. Let's check with the maker of the amendment. Do we want to potentially withdraw this one?
Yes.
Okay.
Thank you, Mr.
Senator
President.
moves to withdraw the amendment. The amendment is withdrawn. Pages, I think we have another amendment. Let's check with the chair of the committee on. We have an amendment, Senator. Pages will collect and distribute the amendment. Okay, Chair may explain the amendment.
Thank you, Mr. President. I think we finally figured this out, and I want to thank both senators for their consultation on this. So we've essentially just added, we've struck the actual website from the statute and have said that they have to just reference that website, and then there's a parenthetical in there so that the form that is actually distributed will put in place the current website, whatever it is. Website does not go in the statute. I think this is the proper balance here.
All right. All right, Senator moved the amendment.
Yes.
Any discussion, discussion on the amendment? Any objections to the amendment? Without objection, the amendment is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 125 is hereby ordered printed for third reading. Off we go. All right, we've got another special order calendar, number 30. Clerk will read the bill. Oh, actually, before we do that, let's do if we could bring the bells quickly. It's a third reader. And if we could do a quorum call.
Mr. President?
Has everyone recorded their presence? So the clerk will take the call. With 46 members in the chamber and a quorum being present, the Senate of Maryland remains in session. We have the third reading calendar. Clerk will read the bill.
Senate Bill 119, Senator Lamb, Legally Protected Health Care, Gender Affirming Treatment. Bill is on third reading for final passage.
Senate Bill 119 is on third reading for final passage. Chair recognizes the senator from the 35th District is on the bill.
Thank you, Mr. President. It seems like it's been a long while since we've had this bill. Just to refresh everybody on this, we had some debate on a possible amendment on second reader, and this is where some information was brought up, and I'd like to clarify. This bill really just pertains to minors because there's no restrictions on adults in any state in the country. Now, on second reader, we heard that wasn't true. There were 2 states, they said, that did have some sort of restriction. So I did a little research to see the accuracy of that. The 2 states brought up were Ohio and Georgia. So in Ohio, the proposed Ohio Health Department rule required counseling before transition measures would have applied to those under 21. The state has since decided to only include minors under 18. Source for that, PBS on February 7th, 2024. Georgia's law, passed June 2023, only regulates gender-affirming treatment for those under the age of 18. Source on that one, the Associated Press. The PBS article goes on to say that absolutely no state has passed any rule or law restricting adults from receiving, quote, gender-affirming health care, end quote, and that the only state who has even considered such a rule, Ohio, only saw that proposed rule apply to those under the age of 21, not all adults. So it goes back to the original point made during that argument, second reader. Anybody that's an adult can have these gender-affirming treatments done without restriction. This totally only applies to minors. Thank you, and that's why I will be opposing putting up a red on this bill. Thank you, Mr. President.
Thank you, Senator. All right, Chair recognizes the minority whip on the bill.
Thank you, Mr. President. So a couple things about this bill I think it's important for the body to know, and my friend from Harford County did a good job of pointing this out on second reader particularly, and again reminding the body today that when we're talking about putting this into the statute under legally protected health care, same with what we did for abortion and abortive services, we are only doing this because we're saying that bring minors here. We'll do the surgeries, the operations. We'll prescribe the medications that can permanently alter their body, permanently alter their hormonal status, can block puberty. We'll do that here, and we want you to be able to come here and not have any state come in and find out what we've done. Now, despite how I feel about what I just said as far as those procedures and whether they should be done to minors, I can understand the temptation to say we don't want anybody's medical records being subject to search, seizure, or whatever. I think there's some things about this bill that are important to note. When we're talking about dealing with minors, what we've got is you're going to have situations where you have split custody, where dad wants something for Susie and mom doesn't, or vice versa. And if they're joint custody and one of them brings them here to do some of these types of procedures, to do some of this kind of health operations, health care, most of these states we're talking about that have restricted care for minors, they're not saying you can't get counseling and services and medication to help you with a hormonal imbalance. They're restricting and generally speaking, I'm sure there's some states that may have gone further, but a lot of these states have just restricted and said you can't do permanent things that a young person, a 12, 13, 14-year-old could live to regret. But putting that aside, what we're doing is we're going to put the state of Maryland in a situation where we'll get battles over people who brought a child here over one other parent's wishes. You're also going to have an issue where you're going to have unaccompanied minors, people coming and saying, I've been emancipated. And I know our health providers are I know we require them to check those things, but it's just setting us up for a big mess. So I think that's a first warning that I would say about why we should vote against this bill. This is a lot different than a grown woman coming for an abortion or some type of reproductive service. These are children coming. But a little beyond that, we heard this during the hearing, and I heard it on the Senate floor Friday. We don't want to get into a re-adjudication of what these kinds of procedures are or what's appropriate. Well, it's interesting because nobody ever seems to want to ever adjudicate it. So I'm not going to get into all the different types of procedures that can be done, that are being done and being offered and at tremendous profit for some health providers to minors. But what I will say is there is growing concern about permanent procedures that have permanent impact on young people who are in a very delicate state in their emotional, psychological, and physical development. I think we need to be very careful about it because we're not just talking, by the way, about 16 or 17-year-olds. We're talking about minors. In the gender-affirming industry, the transgender industry, which has become a health industry now, there's a lot of concern that's developing, and it's not just here in the United States. It's actually developing all over the world. But there was a really interesting article in the New York Times last month written by Pamela Paul, and I would like to read a couple of things from that article. Grace Powell was 12 or 13 when she began to not feel comfortable in her own skin. She was unpopular and frequently bullied, and puberty made everything worse. She suffered from depression and was in and out of therapy. I felt so detached from my body, and the way it was developing felt hostile to me, Powell told me. It was classic gender dysphoria, which is a feeling of discomfort with your biological sex. Reading about transgender people online, Powell believed that the reason she didn't feel comfortable in her body was that she was in the wrong body, body, and transitioning seemed like the obvious solution. And the narrative she had heard and absorbed was that if you don't transition, you could end up killing yourself. This is from the New York Times. At 17, desperate to begin hormone therapy, Powell broke the news to her parents, and they sent her to a specialist to make sure she was serious. And in the fall of her senior year of high school, she started cross-sex hormones, had a double mastectomy the summer before college, and went off to college as a transgender man named Grayson, where she was paired with a male roommate on a men's floor. And at 5'3", she felt that she came across as a very effeminate gay man. At no point during her medical or surgical transition, Powell says, did anyone ask her about the reasons behind her gender dysphoria or her depression. At no point was she asked about her sexual orientation. At no point was she asked about any previous trauma. And so neither the therapist nor the doctors ever learned that she'd been sexually abused as a child. I wish there had been more open conversations, Powell said, who's now 23 and had detransitioned. But I was told there is one cure and one thing to do if this is your problem, and this will help you. And the article goes on to talk a little bit more about there's been a lot of political back and forth on these issues. And I know, speaking here as a Republican and from a conservative perspective, there are people who say, well, you're just inflaming this from a conservative point of view. But there's also been a radical far-out activism on the side from transgender activists that push an ideological extremism. And it's especially been that they've been pressing for a treatment orthodoxy that is facing increased scrutiny in recent years. And again, from the article, many who have in the industry that think there need to be a more cautious approach, there's including well-meaning doctors, people who've undergone gender transition and subsequently regret their procedures. They've been attacked as anti-trans or intimidated to silence their concerns. And Grace Powell said, what should be a medical and psychological issue has been morphed into a political one. And she said, lamenting during their conversation, it's a mess. Parents are routinely warned in these kinds of settings that to pursue any path and we hear this in the testimony in our committee on these bills. Any path outside of agreeing with a child's self-declared gender identity is to put them at risk for suicide, which is really a way to emotionally blackmail people. Proponents of the gender-affirming model have cited studies showing an association between that standard of care and lower risk of suicide. But the very studies that have been cited often have been found to have methodological flaws or have been deemed not entirely conclusive. In fact, a survey of studies on the psychological effects of cross-sex hormones published 3 years ago in the Journal of Endocrine Society, hardly a right-wing rag, the professional organization for hormone specialists found it could not draw any conclusions about death by suicide. And in a letter recently to the Wall Street Journal, 21 experts from 9 countries said that survey was one reason they believed there was no reliable evidence to suggest that hormonal transition is an effective suicide prevention measure. Now, I could go on with some other details from this New York Times article. It's really interesting, and I encourage people to look it up. But let me just conclude with this. Great Britain, Sweden, Finland, and Norway are all slamming on the brakes on pediatric gender-affirming care that's permanent. They're saying we need to slow this down. In fact, in England, the one clinic that does these kinds of long-term operations has closed now. And even France has recommended that puberty blockers, which is one type of treatment that young people will get, again, as young as 11, 12, 13, be defined as experimental. And I know there's this discord between some states that have gone to one level of banning these kinds of procedures and our state, which is sort of like, hey, come on in. Come and do as much as you'd like. I think we're going to look back in the day not too long from now. We're going to look back and say, what were we doing with permanent types of operations, procedures, permanent pharmaceutical changes to people's bodies when they weren't even all the way through puberty yet, or when they've in a very traumatic time as a teenager. And we're not, the industry, I can tell you the industry, and I know it's probably not everybody involved in the industry, but the industry's not asking enough questions when young people come to them. And I think it's very serious. And so, Mr. President, I'm opposing this bill. I mentioned some of the legal reasons, but I am opposing this bill because we need to stop the sprint down this road. Let's take some time, because all over the world, people are starting to question whether we have the right approach on these issues. So, Mr. President, my vote will be red and encourage the body to vote red. Thank you.
Thank you, Senator. All right, any further discussion? Yes, Chair recognizes the bill sponsor on the bill.
Thank you, Mr. President. I would like to ask the body to kind of bring this back to the legislation that's at hand. I know that this body in prior years had discussed and debated gender-affirming treatment, and a lot of the examples that were brought up were really hearkening back to that discussion that had already taken a few years ago. This legislation simply adds gender-affirming treatment to what is already in statute as legally protected health care. Legally protected health care that we placed into statute last year to ensure that women that need abortions can have privacy in their own electronic medical records or medical records from being transmitted out of state or being accessed by out-of-state entities. I know there's been discussion on what other states have been doing for adults, and I do want to highlight the fact that Florida does have a law on the books currently that limits gender-affirming care for adults. West Virginia has a bill that's limiting care for adults. And so this bill is not simply about minors or just simply about adults. It's about all patients that may need gender-affirming treatment. And this bill also has nothing to do about minor consent. That has been thoroughly debated in the prior legislation that was passed. To be clear, parental consent is still needed. Nothing can be done without parental consent. This changes nothing about how care is provided to minors. If a minor is needing hormonal treatment that needs parental consent, nothing permanent can be done surgically without parental consent. There were examples brought up about cases where someone might have joint custody over a child and how that might be adjudicated when it comes to these electronic medical records. Those records are oftentimes stipulated in terms of the custodial agreement between the parents and also stipulated in federal law in HIPAA how those records should be handled in the cases of joint custody. This bill is simply about protecting patients and their providers from care that we have already agreed should be provided to these individuals if it is medically necessary and important with the determination of their healthcare provider. The intent here is to protect Maryland patients and providers from the care that they need and being able to offer care and the options that are available for these patients without the concern of being politicized. So with that, I urge the body to have a green vote on this bill.
All right, on the bill, any further discussion? If not, the clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If
Mr.
not,
President?
Oh, yes. Senator from District 6 has 2 minutes to explain his vote.
Yes, I'm going to be very quick, Mr. President. This might give parents consent, but I think in time it would be minors' regret. And I believe that's very true because there's decisions that young people have made. And when they made that decision, maybe they got the permission from the parent. But I think in time, there might be a lot of regret in that. So this is a life-changing thing that's going to happen. And I believe that this is something that would just change somebody's life for eternity. And they can't turn back. So that's why I voted red, Mr. President.
Thank you, Senator. All right, any further senators wish to explain their vote? If not, the clerk will take the call. With 33 votes in the affirmative, Senate Bill 119 having received a constitutional majority is declared passed. All right, that does it. That's desk is clear. Long day, good day. We got through a lot of stuff, Important note before we do committee announcements, just for scheduling, and I know everyone is busy and will continue to be busy for these next 2 weeks, but especially for the week after crossover. If you have not scheduled your meeting with Dia Daly, please, please, please make sure that you get that done. We have about, 34 days left. It's essential everyone's required to do the meeting for our annual ethics check-in. Please, it's like going to the dentist, and Dia's much more pleasant than most dentists. But please make sure you schedule your meeting with her. All right, let's see. Chair of Finance.
Thank you, Mr. President. Finance will meet at 1:15 today. We have 16 bills and 140 witnesses, so please be on time, but give a little extra time for lunch. Thank you.
Thank you, Senator. All right, Chair of Education, Energy, and the Environment.
Thank you, Mr. President. Triple E will also meet at 1:15. Today we have 10 bill hearings and we have 131 witnesses.
131. Whew. Chair of Budget and Tax.
3:30, capital budget.
3:30, capital budget. Thank you.
Thank you, Mr. President. Judicial Proceedings Committee will meet today at 1:15 for bill hearings. 12 bills, 90 witnesses.
Wow. Lots of hearings this late. Lots of bills. All right, let's see. Any other standing committees? Select committees? Yes, co-chair of the protocol?
Anne Arundel County.
Anne Arundel County.
Thank you, Mr. President. The Anne Arundel County Senate delegation will be meeting afterwards in the Silver Room. However, I would ask that our male members of the delegation be patient with us so that the lady members can take our picture real quickly for today. Thank you very much. Thank you, Mr. President.
Excellent. All right, any other announcement? Yes, Montgomery County delegation?
Thank you, Mr. President. MoCo Senate colleagues, immediately following session, again this Thursday, we did an amazing job knocking out those bills last week, but we were left with just a few that we will be taking up this Thursday immediately following floor session. Thank you.
An amazing job. I love it. Yes, Prince George's County delegation.
Thank you, Mr. President. Prince George's County will meet tomorrow night at 5 o'clock in the NEO conference room. Thank you.
Excellent, thank you. Senator from the 37th District, protocol?
Yeah.
Yes.
The Protocol Committee has an announcement to make. We have two announcements to make today, Mr. President. Permission to use the senator's name.
Senator may proceed.
Today we are celebrating a birthday for our senator from Mountain, Maryland, Senator Mike McKay. Let's give him a big round of applause and a happy birthday. And if the body's ever heard of the phrase "a twofer Tuesday," we have a twofer. I'd like to also get the body to give a big round of applause for our senator, who is now nationwide famous, from Montgomery County, Senator Ben Kramer. Happy birthday!
Happy birthday! Very famous. That's true. Nationally, yes, Senator.
Just a point of personal privilege. Thank you, Mr. President. I don't know whether you all have noticed the incredible resemblance, and that I always knew there was a twin out there, and we were separated at birth. And now I have figured it out. Look, it's like looking in a mirror.
The doppelgangers. The doppelgangers are there. Beautiful. It's a beautiful day here in the Senate of Maryland. Birthday specials. All right. Anything else for the good of the order? Yes, Chair, recognizing the Majority Leader.
Thank you. Just a quick reminder to the women of the Senate that we'll be meeting out in the lobby right after session to have our pictures taken with our yellow sashes.
Right in the
And
lobby?
I have them.
Excellent. Anything else? Anything else? If not, quorum call.
Mr. President?
Has everyone recorded their presence? If so, the clerk will take the call. With 44 members in the chamber and a quorum being present, the Senate of Maryland remains in session. Chair recognizes the Majority Leader.
Thank you, Mr. President. I move the Senate of Maryland stand adjourned until Wednesday, March 6th at 10 a.m.
10 a.m. Have a wonderful and productive day, everyone. So ordered.